to it, which people have, in fact, most people are not even aware of it. We were the first ones to place this before the court. The temple receives 51 lakhs from the Consolidated Fund of India through the state government as a consequence of Article 290A. This article was amended, I think, in 1956 because the amount was increased at that point of time. From 46 to 51 lakhs, an amount was increased. Why was this increased? How is the state going on increasing this? There is a reason for it. In 1922, there was no constitutional India as we know it today. It was still princely states. This temple fell within the Travancore princely state. The Travancore princely state took over all the lands of that particular temple for the purposes of management of that particular temple and said, we are taking away your lands and in return you will get 51 lakhs or a certain amount every year for the lands that we have taken, which was the primary source of your revenue and income for your upkeep and maintenance. When the Travancore princely state merged with the Union of India, there are covenants of mergers which were entered into between the princely states and the Indian Union. So we placed that particular proclamation of 1922 through the 1939 Travancore Manual, which captures this particular announcement by the king of Travancore who says, I'm taking over these lands and I shall give rent in return. Okay. So when the Indian state took over, it also took over the liabilities and the assets of the princely states. Okay. Therefore, when the Indian state took over, it also took over the lands. Yes. And therefore it had to pay the rent. Therefore, this is not some kind of a dana or a charity or a fund.
This is just rent.
This is rent that the Indian state owes for having taken over the lands of the temple. Therefore, this is not state funded. Not one iota of money comes from the state to this particular temple because it cannot, it is unconstitutional. Right? This factual history, the petitioners did not place before the court. Nobody placed before the court. We were the first ones to place before the court. Secondly, the 7-judge bench of the Supreme Court in 1954 in the Shirur Mutt case clearly said that the state shall not interfere with the religious practices of an institution. It shall only be responsible for the secular aspects of administration under 25(2)(a). Therefore, just because you give money, assume that you are actually giving money as dana or contribution, you have no right to interfere with the religious practices. Even that is the law. First of all, it's not your money. It is my money that you're giving back to me. 2, in this case, it is, so the relevant provisions would be Article 15.1 and 15.2. 15.2 speaks of prohibiting discrimination on the basis of gender or whatever the considerations may be. And it lists the different places where this discrimination shall not be allowed. There is no reference to a place of worship. Right. Therefore, discrimination on the basis of gender is not illegal under Article 15.2. First of all, this is not discrimination and therefore exclusion is possible. Then the question is Article 15.1, can the state do this? This is run by the state only for the purposes of administration. The Travancore Devaswam Board is an administrative body, not a religious body, which has absolutely no say as far as the religious practices of the place are concerned, because they are a body constituted under the 1951 Endowments Act, which applies to Travancore. Okay. Therefore, it is a body whose primary duty is only secular administration, which is cleanliness, management of the crowds, payment of salaries, nothing beyond that. That is because religion entirely falls within the scope of the temple itself. Okay. Now, the law on this is slightly different if you go further. Assume that the state forces the temple to violate its religious practices, or the temple itself violates its religious practices. Under this, the law clearly says this. If someone who is supposed to be the guardian of the religious sanctity of the place abandons his duties, then the devotees shall take upon themselves the right and the duty to preserve that particular religious practice. Therefore, as a devotee, I have the right to go to court